Sylvia? Voilà.
Oui,
C'est bon?
ça y est.
Ça y est, c'est bon. D'accord, merci
C'est bon.
beaucoup. Bon, d'accord.
Merci.
Moi, je suis à la maison, pour ça, je ne mets pas. Bon, allez, à tout de suite. Alors, hop, je vais commencer. Je vais chercher mon cours. Alors, so today we are going to talk about the abortion in the light of the different case law of the European Court of Justice. And we are going to explain today the difference between the different legal issues within the European Union law. So, the first of all, so the first of all, the question about the voluntary termination of pregnancy or abortion raise another legal issues within the European Union, and this the first legal issues is of course the research, the legal research, the legal research on the human embryo. The reference to the human embryo goes back a long way. It can be found as early as 1989 in two European Parliament resolutions adopted on the same day, one on in vivo and in vitro fertilization, and the other on the ethical and legal problems of genetic manipulation. In these resolutions, the European Parliament highlighted two main ideas: the affirmation of the human nature of the embryo and its protection from fertilization until after death. According to these resolutions, a number of principles should govern the scientific use of human embryos. These principles include a ban on artificially keeping human embryos alive for the purpose of timely removal of tissues and organs, a ban of the marketing of cryogenically frozen embryos, whether for scientific, industrial, or commercial purposes, a limit on the number of fertilized eggs, and the exceptional use of dead embryos or fetus for diagnostic purposes. Finally, the parliamentarians drew attention to the fact that interventions or experiments on living human embryos or fetuses are only justified if they represent a direct benefit and if they cannot be obtained by other means for the well-being of the child and the mother. The ethical problems of research on embryos in vitro or on embryonic cells were subsequently raised by the European Groups on Ethics. In its opinion, ethical aspects of research involving the use of human embryos in the context of the fifth Research Framework Program, it strongly emphasized the need to provide a framework for such research insofar as there was no conceptual convergence in the member states regarding the definition of the embryo. However, the European Group on Ethics considers that the research on embryos should not be excluded a priori from funding at European Union level because of the scientific advance that such research may present. In its opinion, the group specifies that such research can only be authorized after an ethical evaluation. This ethical assessment must take account of number of principles, as the principles of respect for human life and respect for the consent of the women or couples concerned. In addition, the European Group on Ethics points out that the research project must comply with national requirements. It must have been approved by the relevant national ethics committees. To avoid arbitrary research, the European Group on Ethics also recommends strict public control while ensuring maximum transparency. Finally, the ethical evaluation must be made public. Must be public. So, three principles were reiterated in its opinion on the ethical review of research projects under the seventh framework program in the field of human embryonic stem cell research, presented in opinion number 22. The European Groups on Ethics points out that human embryonic stem cell research conducted in accordance with a responsible ethical approach must comply with fundamental ethical principles and human rights in the European Union, from stem cell procurement to clinical research activities involving human embryonic stem cells. Respect for these principles implies continuous efforts to ensure their protection, the recognition and promotion of human dignity and human rights, and more concretely, implies defining priorities in medical research. For the European Groups on Ethics, there are four general criteria that allow scientific research to be encouraged and ethical principles to be respected. Scientific necessity and the high status of the research, urgency, social desirability, and the primacy of the interest and well-being of the human being over the exclusive interest of society or science. In addition to these four criteria, the group adds two further criteria concerning the need for research: the non-availability of validated alternatives and the non-redundancies of projects under the seventh framework program. In addition, the ethical review must take into account several parameters. The impossibility of carrying out the research on alternative human stem cells, adults, prior research on animals must have been carried out satisfactorily. The research must present future benefits in terms of human health or biomedical knowledge that cannot be achieved by alternative means. The absence of any other solution for achieving the objectives of the project, full scientific justification for the research project must relate exclusively to non-implanted in vitro fertilized embryos. The non-commercialization of the embryo must be preserved. To avoid arbitrary experimentation, the European Group on Ethics strongly recommends the promotion and development of ongoing public debate and dialogue between science and society. Such a position is not without certain conceptual difficulties as regards the determination of the embryo in the light of the rights inherent in human dignity, in particular the right to live and the protection that must be afforded to it. The case of law of the Court of Justice is ambiguous in this respect. While it does not recognize the social protection rights of women who undergoes in vitro fertilization because she could not be considered to be pregnant before the embryo obtained was implanted in utero. The Court of Justice adopts a broad interpretation of the concept of embryo, referred to in Directive 98/44 in order to strictly circumscribe the patentability of biotechnological inventions relating to embryonic stem cells. However, this broad interpretation was subsequently limited by a case-by-case assessment of the potential development into human life of an unfertilized ovum stimulated by technological processes. This difficulty inherent in taking a moral and political stance on the right to life was also highlighted in the One of Us Citizens initiative. We were talking about this citizen initiative last week. So do you remember about the scope of this case law on the One of Us Citizens initiative? It was contested. The financing of the European Union of the research project on embryo cell stem, and in this case law, it called on the Commission to exclude scientific research projects from funding under the program Horizon Europe Framework Program. as well as any inventions that may result from such projects if they are based on the destruction of a human embryo obtained in vitro. The issue could have passed, could past and been dealt with essentially from the point of view of the Union's competencies, as the Commission had done in its communication. But it also deserves to be analyzed in the context that preceded the Brussels case law. Prior to this judgment, the European Patent Office had considered that when embryonic stem cells are simply isolated from the human body by technical operation, these cells become patentable biological material. However, the European groups on ethics had ruled out the possibility of patenting invention based on embryonic stem cells. Similarly, in its resolution on the framework program for the funding of scientific research, the European Parliament called on the Commission to continue to use the current method and will not submit to the committees acting in accordance with the review procedure any project proposal involving research activities that imply the destruction of human embryos, including for the supply of stem cells, just because this stage of research is excluded from funding does not mean that the European Union cannot fund subsequent stages involving the use of human embryonic stem cells. The European Parliament had already called for an optimum political, legislative, scientific, and economic effort to be made to promote therapies using germ cells harvested from adults or not involving the destruction of human embryonic life. The Brussels judgment was also along this interpretation. In this context, it can be said that the text and case law seem to focus on a central idea. The embryo, in its early stage of development, is not yet the subject of rights, but because it is human life, it should be protected. The issue of research and the patentability of embryonic cells has reopened the debate. A European position on the protection of the embryo could emerge in the future from the reconciliation of declared ethical principles with the economic interest protected by patentability. In the Brussels ruling, in the Brussels case law, the Court of Justice held that the use of human embryos for scientific purposes could not be patented. The protection of the human embryo in the name of human dignity precluded any possibility of obtaining a patent on an invention that has necessitated its destruction. In order to prevent the authors of certain biotechnological inventions from being tempted to apply for patentability in member states with the narrowest conception of the concept of the human embryo, the Commission has chosen to give an autonomous definition of the concept of the embryo. It also points out that patent law must be exercised in compliance with the fundamental principles guaranteed human dignity and integrity, and that processes whose application undermines human dignity cannot be patentable. In order to ensure true respect for human dignity, it interpreted the concept of embryo broadly, considering in particular that any human ovum must, from the stage of its fertilization, be regarded as a human embryo within the meaning and for the application of Article 6 of Directive 98/44. The principle of human dignity thus leads to the adoption of an extensive definition of the human embryo. If the court considers that an unfertilized human ovum, which by means of parthenogenesis has been induced to divide and develop, does not constitute a human embryo within the meaning of Article 6 of the Directive. It is because, in the light of current scientific knowledge, it does not as such have the intrinsic capacity to develop into a human being, which is a matter for the national court to ascertain. In addition, the European Parliament resolution of 7 September 2000 in favor of banning human cloning, whether for reproductive or therapeutic purposes, took a stance against authorizing the creation of embryos in vitro for research purposes, in other words, rejecting therapeutic cloning. However, it came up against the contrary opinion of the European Group on Ethics attached to the European Commission, which does not rule out the creation of embryos for research purposes. Similarly, the final decision adopting the 6th Research Framework Programme did not prohibit the funding of research activities involving the creation of human being for experimental or therapeutic purposes. Now I'm going to talk about it to explain the second legal issues raised by the question of abortion and voluntary interruption of pregnancy. This is the second legal issues concerned the access to medically assisted procreation, surrogacy, and social protection for women. So, artificial procreation is traditionally considered in terms of the ethical issues involved in medical manipulation of a woman's bodies. Today, however, it raises more questions about the status of women and their relationship with motherhood, which are confronted with other interests, those of the child resulting from artificial procreation and one of the family unit. European Union law is not unfamiliar with these issues and is providing the beginnings of a response. With regard to the status of women and their relationship with maternity, European Union law has from the outset contributed to the development of national legislation on the protection of women pregnant, breastfeeding, and even postpartum situation. The role, of course, the right to maternity leave and the prohibition on dismissal during this period. However, the seemingly favorable European regulations only protect one category of women, those who are physiologically pregnant and who have physically given birth. It is this physical biological relationship of the woman as determining her status as mother that seems to emerge from the case law of the Court of Justice. This biological approach was already apparent in the Sabine Meyer case law judgment, in which the Court of Justice ruled that the protection against dismissal of pregnant women did not apply to women awaiting in vitro fertilization procedure, as the embryo obtained in vitro did not constitute a pregnancy in utero without transfer. More recently, still, and more significantly, the Z and CD judgments quoted in the syllabus I send it. In these judgments, this judgment handed down on the same day, attest to the political nature of the legal debate that can arise before the Court of Justice in relation to artificial procreation. On the basis of the objective of the secondary legislation reliant on, which is to protect women in their vulnerable postpartum state, the court ruled that this provision was inapplicable in this case, given the particular nature of surrogacy for the mother of intention. This position tends to reduce maternity to women's body, raise the question of the value that legal systems are fundamentally seeking to protect when they introduced such leave. Is it woman's body or the social role of parent? The answer to this question will also determine whether and how maternity leave discriminates. As Stephanie Annette Vaucher rightly points out, I'm quoting, the market paradigm is not morally neutral. Freedom of movement and the mechanical application of the categories of European Union law depend on axiological options. This is reflected in the principal position of the European Parliament, which strongly condemns surrogate motherhood in its motion for a resolution on surrogate motherhood as a risk to the rights of women and children. In this motion, the European Parliament called on the Commission to define a legal framework for the protection of children already born to surrogate mothers and those who will be born, and to verify that the regulations on surrogate motherhood in force in the member states, where it is authorized, do not run counter to European Union legislation on the protection of children's and women's rights. This organic link between the mother and her unborn child is once again in danger of being questioned and called into question. Indeed, as part of the Horizon 2020 framework program, the European Union has funded the PLS project, Perinatal Life Support System, integration of enabling technologies for clinical translation, which began in October 2019, led by a multidisciplinary team headed by the Eindhoven University of Technology in the Netherlands. Research into a prototype artificial womb is expected to revolutionize the care of babies born prematurely and reduce the risk of development. Nonetheless, this prototype will raise new ethical issues in the future concerning the viability and, therefore, the survival of a fetus born too early. What protection should be afforded to the right to life, and from what point onwards the physical relation between mother and child and the concept of maternity, particularly in the case of in vitro fertilization and a woman's inability to accept the embryo thus obtained. And now I will conclude this presentation with the third Lego issues raised by the consideration in relation with the abortion and involuntary interruption of pregnancy. The third Lego issues concern the status of the child resulting from an in vitro procedure. The status of children born as a result of artificial procreation raises two ethical issues that need to be reconciled. The first is the right to know one's origin when the artificial procreation has been carried out using donated gametes or sperm. Then there is the question of preserving donor anonymity. While this is essentially a matter for the political choices of the member states, the problem is likely to arise at European Union level for two reasons. First of all, the new regulation of human substance in accordance with the ancient Directive 2004/23 applies to reproductive cells, and these cells may circulate within the European Union as a part of reproductive medical care. This reconciliation between the right to know one's origins and the preservation of anonymity may also influence the very concept of donation, in particular its free, altruistic, and voluntary nature. Above all, however, it highlights the best interest of the child in its social determination and within the family unit. It is through the right to privacy and family law, excuse me, that the European Union law can potentially address the status of the child born through artificial procreation. Family law has also evolved under the impetus of the European Union law through the prism of freedom of movement and European citizenship. That's the different case law. I quote it in my syllabus. So Pancherevo, and of course the Polish affair, the Polish case law about the recognizing of double motherhood of the mothers in the certificate of birth, on the certificate of birth, and the quality of European citizen of the child which was born thanks to artificial procreation. It is the newest legal issues that the member states have to face because of the free movement because the free movement based on the European citizenship. So I will. So do you have any questions? Everything is okay? Do you understand what I exactly mean? Do you have any questions about? Okay, so let's start again, and I will explain you the other ethical issues, which was in deep connection with the European Union law. So, after this situation is, I have to talk about the different position concerning the cloning within the European Union. As early as 1989, in its resolution of 6th March 1989 on the ethical and legal problems of genetic manipulation, the European Parliament, the European Parliament prohibit genetic manipulation with a view to cloning as contrary to human dignity. Indeed, this is a general principle within the European Union position. The ban of cloning is a position of principle adopted from the outset within the European Union. Similarly, in its resolution on the cloning of the human embryo of 28 October 1993, the European Parliament had already expressed a strong opinion on the prohibition of human cloning, whatever the purpose of such cloning. It states that whether carried out for experimental purposes in the treatment of infertility, preimplantation diagnostic, or tissue transplantation, or for any other purpose whatsoever, is unethical, morally abhorrent, and contrary to respect for the individual, and constitutes a serious violation of fundamental rights, and therefore can in no circumstances be justified or accepted. The European Parliament has also reiterated its firm position on cloning in the proposal for a directive on the legal protection of biotechnological inventions. According to the European Parliament, cloning is considered to be contrary to public order and morality, and all processes of human reproductive cloning must be unequivocally excluded from patentability. This point is expressly included in Article 6 of Directive 98/44. This position of the European Parliament is constant. It did not hesitate to state in its resolution on the cloning of animals and human beings, adopted on 12 March 1997, that cloning would not be accepted in any society whatsoever. For the European Parliament, cloning is a serious violation of fundamental human rights. It is contrary to the principle of equality of human beings because it allows eugenics and racist selection of the human species. It offends the dignity of the human being, and it requires experimentation on humans. In this resolution, the European Parliament goes further, calling on the member states to ban human cloning and expressly asking researchers and doctors to refrain from any involvement in human cloning until a legally binding ban comes into force. It also calls on the Commission not to fund research projects aimed at developing human cloning methods. The European Council has also called for a ban on human cloning. In its declaration on the prohibition of human cloning of June 1997, the Council emphasized the incompatibility between the protection of human beings and respect for their integrity and cloning. The prohibition of human cloning has also been advocated by the European Council. In its declaration on the prohibition of human cloning of June 1997, the Council emphasizes the incompatibility between the protection of human beings and respect for his integrity and cloning. And of course, the European Group on Ethics opinion number 9 of 28 May 1997 confirms this approach to banning human cloning. According to the group, cloning should be unequivocally condemned at European level. Such a ban was justified because of the abuses that such practice could lead to, in particular request for personal convenience, desire for immortality, choice of the child's sex, replacement of deceased child. That could go as far as eugenic practices. Even more recently, the European Group on Ethics expressed its views on the issue of animal cloning. In its opinion 23, the group considered that further studies and analyses should be carried out on the long-term animal welfare and health consequences for clones and their offspring, as well as comparative analysis against other assist or traditional reproductive techniques in animal husbandry in order to properly assess the issue. The Commission should take initiatives to develop a code of conduct on responsible animal husbandry, also covering cloning. The Commission must take the necessary steps to protect the genetic heritage of farm animal species, For example, by founding projects to protect domestic breeds in Europe and promote sustainable agriculture. In the group's view, the ethical, legal, and social consequences of animal cloning for food production need to be further clarified and qualitative studies carried out on how it is perceived by the general public. Now, the Article 3 of the Charter of the Fundamental Rights expressly prohibits eugenics practices and the selection of individual and reproductive cloning. And the last legal issues concerning the ethics about the abortion and human embryo manipulation is the topic about genetics. The reference to genetics in European Union law is not an isolated one. It is specifically linked to the ethical questions that genetics may raise when it comes to medical procedure linked to genetic engineering, either to correct a genetic anomaly or to prevent the transmission of this anomaly. Ethical issues generally concern the right to inherit genes that have not been modified or manipulated in any way. This right finds particular expression in the European Parliament's resolution of 16th March 1989 on the ethical and legal problems of genetic manipulation. In this resolution, the European Parliament advocated the recognition of a right to genetic identity, the right to reserve a genetic identity it only has declaratory values and merely demonstrates the commitment of the European institutions not to modify human genetics. However, this right to genetic identity, I will repeat, has not binding value because it is not enshrined in binding legislative acts. It only has declaratory values and merely demonstrates the commitment of the EU institutions not to modify human genetics. The ethical issues in genetics arose with the development of genetic manipulation of DNA and the economic spin-offs that this technique could generate. This is why the ethical issues of genetics was raised when Directive 1998/44 was drawn up, and in the context of the patentability of living organisms. In this respect, two problems arise. On the one hand, the opposition between invention and discovery, and on the other hand, the patentability of a genetically modified human body. The directive provides only a partial response to these two problems because of the ambiguity that it may create regarding the prohibitions on patenting and the concept to which these prohibitions refer. Even more recently, the ethical questions has also arisen in relation to genetic testing and prenatal diagnosis. The European Union institutions specified that the sole purpose of this test should be to detect genetic diseases so as not to lead to the selection of human beings, gender, sex, physical characteristics. The ethical issues of selecting unborn fetuses has also been revived by the development of prenatal diagnostic tests, which can now identify fetal DNA in the mother's blood. The test is not invasive one, requiring only a blood sample with no risk to either mother or child. And the use of genetic tests can also lead to genetic discrimination, as the European Group on Ethics has already pointed out. The main ethical issues relate either to the performance of genetic tests themselves or to the use of genetic data obtained by means of this test. It considered that the use of genetic tests in the employment context, as well as the disclosure of previous genetic test results, are generally unacceptable from an ethical point of view. In fact, the employer may satisfy his legitimate duties and rights in terms of health protection and assessment of aptitudes by means of a medical examination, but without carrying out genetic tests. The employer must in principle refrain from carrying out genetic screening or asking the employee to undergo testing. In its opinion number 18, it expressly condemned the practice of such a test in the context of employment. In justifying this position, the group referred explicitly to the unreliable nature of their results, as there was no conclusive evidence of the relevance and reliability of existing genetic tests in the employment context, and that their predictive value remains uncertain. Furthermore, it considers that the use of genetic tests in the context of employment, as well as the disclosure of previous genetic test results, are generally unacceptable from an ethical point of view. In fact, the employer can fulfill his legitimate duties and rights in terms of health protection and assessment of aptitudes by means of a medical examination without carrying out a genetic test. In principle, the employer must refrain from carrying out genetic screening or asking the employer to undergo testing. In the European Group on Ethics view, only genetic monitoring could be authorized in exceptional cases where the worker is exposed to risk of genetic modification. Genetic modification. And now I will talk about, and now if there are some any questions about what I'm talking about. No? Everything is okay? Is everything is okay? Okay, so I will try to explain the next chapter of our courses, and which concern the new topics, and the third topics of our courses will focuses on the economic uses, the economic uses of the element of the human body, and the ethical issues raised from raised by the biotechnologies with the biotechnologies. So I will try to present you another aspect of the European Union law of the bioethics, the exercising the economic activity within the Euro and bioethics. If you don't have any questions, so I will continue with the topics, the third topics of our courses. So the exercises economic activity within the European Union and bioethics. The opening up of the internal market to body parts and medical services, including reproductive ones, allows them to move from one country to another. This free movement takes place via medical professionals, private individuals for targeted scientific use, or as a part of medical treatment. In an exponential way, it widens the possibilities of their use and can lead to their being subjected to the logic of the market. In this context, the bioethical issues have essentially been revealed by the free circulation that encourages economic activity. On this point, European Union legislation is very explicit. Article 3, paragraph 2 of the Charter of Fundamental Rights is a strong reminder of the prohibition in principle on the economic exploitation of the human body and its parts, affirmed in principle by all the text on European Union law. This prohibition limits the exercise of economic activity and condition the donation of human body parts and products within the European Union. So, first of all, we are going to talk about the prohibition in principle on deriving economic benefit from the human body and its part, a limit on the exercise of economic activity. The question of the non-commercialization of the human body as a limit on economic activity has mainly arisen in connection with scientific research involving the human body and in its commercial exploitation, and the freedom to provide services involving the human body and its part. So now I will focus my propos on the commercial exploitation of scientific research involving human body. The importance of the debates on the commercial exploitation of scientific research involving the commercialization of the human body became apparent during the drafting of the Directive 1998/44 on the legal protection of biological invention by means of patent system. As compromised text based on the prohibition of profiting from the human body, the directive is ambiguous in this respect. So, I will see this point, the first of all, the patent protection for biotechnological invention and the non-commercialization of the human body. The introduction and the human body, and the second point, and the second point, it will be the ambiguity of the text of the directive. The introduction of the European patent system comes at a time when there is a political desire to improve competitiveness within the internal market. In its white paper on completing in its white paper on completing the internal market, the Commission highlighted the need for the community to have a patent system in the field of biotechnology. For the European Group on Bioethics, patent law is one of the stimulants of medical research, as it allows compensation for research efforts whose progress, both diagnostic and therapeutic, benefits patients, in particular those suffering from genetic diseases. The purpose of a patent is to grant a monopoly on the economic exploitation of an invention based on elements of the human body. It is an industrial property right over an invention. The aim of the patent system to ensure a compromise between the particular interest of the inventor and the general interest of the community. On the other hand, the patent aims to protect the invention and defend the inventor's rights. The state offers the inventor temporarily exclusivity of the right to exploit his invention, thereby protecting him from counterfeiting and technical plunder. On the other hand, the patent aims to protect the invention and defend the inventor's rights. The states offer the inventor temporarily the exclusivity of the right to exploit his invention. In return, the invention must provide a precise description of his invention. This disclosure constitutes a contribution to the body of existing technical knowledge and enriches the state of the art. Thus, in the general interest of the community, the patent system, by avoiding secrecy, does not block knowledge, but guarantees the freedom of research and the freedom of researcher to exchange information. While the protection of biotechnological inventions is of great interest for the competitiveness of European scientific research, they undoubtedly raised ethical issues concerning the patentability of a living organism. It is not surprising, therefore, that the initial version of the Commission's proposal for a directive gave rise to a lively debate in the European Parliament, particularly on the subject of banning certain patentable processes relating to the human body. In its resolution on the ethical and legal problems of genetic manipulation, the European Parliament had already taken an open stand on the importance of protecting the individual and his or her body with regard to scientific research. Similarly, in its 1996 resolution on the protection of human rights and dignity of the human being with regard to the application of biology and medicine, it expressly stressed that no living human organ or tissue shall be bought, sold, or otherwise treated as a marketable commodity. The final text of the Directive 98/44 seeks to reconcile the importance of economically stimulating scientific research and protecting it by means of a patent with the ethical principles inherent in the human body. Article 3, paragraph 1 of the directive specifies its extended scope. New inventions involving an inventive step and capable of industrial application shall be patentable. Even where they're related to a project composed of or containing biological matters or to a process for the production, treatment, of use of biological material. Similarly, paragraph 2 of this article extended to any biological material isolated from its natural environment or produced by means of a technical process. because it may be the subject of an invention, even when it pre-existed in its natural state. This broad scope is counterbalanced by the limits imposed on patentability. On this point, the directive seems clear, as it embodies all the positions taken by the European Union institutions, right from its recitals. Recital 16 stressed that patent law must be exercised in compliance with the fundamental principles warranting human dignity and integrity. And the principle should be reaffirmed that the human body, at every stage of its formation and development, including germ cells, and the simple discovery of one of its elements or product, including the sequence of partial sequence of a human gene, are not patentable. Recital 23 states that the simple DNA sequences without any indication of a function does not contain any technical information and cannot therefore be considered a patentable invention. Article 5 of the final text of the directive states that the human body, at the various stages of its formation and development, and the mere discovery of one of its elements, including the sequence of partial sequence of a gene, shall not constitute patentable inventions. An element isolated from the human body or otherwise produced by a technical process, including the sequence of partial sequence of a gene, may constitute a patentable invention, even if the structure of that element is identical to that of a natural element. Article 6 of the directive states that invention, the commercial exploitation of which would be contrary to public order or morality, shall be excluded from patentability. In particular, processes for cloning human beings, modifications of the germ line genetic identity of human beings, the use of human embryos for industrial or commercial purposes of processes affecting the genetic identity of animals which are likely to cause them suffering without any substantial medical benefit for humans or animals may not be patented. The directive establishes a boundary between man and between human being, and other forms of life by devoting a specific provisions to the patentability of the human body and its parts. It also sets out 3 examples of inventions that are excluded from patentability on the grounds that they are contrary to public policy: the cloning of human beings, genetic modification, and the use of human embryos. The provisions of the directive have been incorporated into the implementing regulations to the Convention on the ground of European patents in such a way that their effective application can be guaranteed by the European Patent Office. Even though only 40% of patent applications fall within the scope of these provisions. However, although the limits imposed on patentability appear clear, at first sight, the system remains ambiguous. So, in the second point, I will develop, as you can see, the ambiguity of the provisions of the directive. The generality of the terms used in the text of the directive makes it impossible to define precisely which elements of the human body are included from patentability and which inventions, if they relate to the human body, the commercial exploitation of which is contrary to public order and morality. While paragraph 1 of Article 5 excludes the human body from patentability in principle, paragraph 2 authorizes the commercial exploitation of an invention relating to an isolated element of the human body through patent protection. This paragraph calls into question the ethical principle of non-commercialization of the human body because it makes the distinction between discovery and invention applicable to the human body and its isolated elements. However, the distinction between discovery and invention is not the easiest to establish when it comes to elements of the human body. It is conceivable that the human gene, isolated from the human body, is an invention and can therefore be commercially exploited under patent protection. Does the concept of invention apply to the isolated gene or to the technical process used to isolate the gene? Under the directive, the line between invention and discovery is blurred because it does not specify the concrete criteria for making this distinction operational when applied to the human genome. Far from being a hypothetical question, this issue has already been raised in the context of the medical research on DNA and its economic exploitation. The question was whether the process used on human DNA was a discovery or an invention within the meaning of Article 5 of the directive. To answer this question, it was necessary to determine whether the human genome, representing the sum of genetic information as an essential element of the human body, could give rise to technical inventions. This point is not expressly settled in a clear and precise manner in the directive. So I will take 5-10 minutes to break and I will continue. Thank you very much. second, concerning the patent law, which is applied the human elements, the elements of the human body. So let's start for the last hour. It will be okay. If you have any question, don't hesitate. Don't hesitate to raise the hand, to raise your hand, and to interrupt me, and to discuss. I finished my presentation about the DNA and the specific nature of DNA, and that the DNA representing the sum of genetic information as an essential element of the human body. The prima facie approach is to consider the human body as a single global entity, and consequently to exclude any patentability of the human genome, which would in principle also be contrary to the good morality referred to in Article 6 of the directive. Yes? Everything is okay? Excuse me? Everything is okay?
Yes, okay.
Yeah.
Okay. Perfect. So, we will continue. So, the prima facie approach is to consider the human body as a single global entity, and consequently to exclude any patentability of the human genome, which would in principle also be contrary to the morality referred to in Article 6 of the directive. In its decision of 16 July 1997, the European Patent Office stated that the human body, at the various stages of its formation and development, as well as the mere discovery of one of its elements, including the sequence of partial sequence of gene, cannot constitute patentable invention. In a 1994 decision, the same office held that the DNA is not life, but a substance carrying genetic information, and that a patent of a single human gene, of a patent on human life, are two quite distinct things. Consequently, isolating and characterizing a DNA fragment coding for a human protein does not constitute a discovery, but an invention. Finally, there is nothing morally wrong with such a human invention. The directive endorses so the position of the European Patent Office. Its main objective remains the guarantee of the competitiveness of enterprises within the European Union. Ethical principles are thus relegated to the background. This situation was also highlighted by the Commission in its report on the application of the directive. Indeed, in point 2.1 of the report, the Commission highlighted this difficulty with regard to patents on the sequence of gene. It stated that according to Article 5, Paragraph 3, and Recital 23 and 25, the community legislator intended at least to consider the possibility of limited protection, covering only the specific industrial application identified in the patent, to the extent that this particular type of invention is concerned. Otherwise, Article 5, paragraph 3, which requires that the industrial application of a gene sequence be concretely disclosed in the patent application, merely repeats a standard requirement of general patent law as shown in recital 22 of the directive. The directive endorses so as shown in recital 22. The informal expert group in March 2003 met in March in 2003 to discuss this issue. A majority of members felt that there were no objective reasons for creating a specific regime on function-based protection in this area, which differs from conventional patent protection. In particular, the technical and legal expert felt that the experts saw in particular, the technical and legal experts felt that there were no differences between DNA sequences and chemicals that would justify a different treatment with respect to the extent of protection conferred by a patent. The European Parliament, for its part, asked the European Patent Office and the Member States to grant patent on human DNA only when they are limited to a concrete application, demand also that the scope of the patent be limited to the specific application so that other users can use and patent the same DNA sequence for other application. Function-based protection. Similarly, the Parliament also invited the Commission to examine whether this interpretation of the directive could be obtained in the form of a recommendation to the Member States, or whether it is it is necessary to amend Article 5 on the directive for that purpose. It justified its position by the principal postulate that no consideration in research can take precedence over human dignity. The ambiguity of Article 5 of the directive was strongly criticized. The doctrine even considers that paragraph 2 contradicts paragraph 1 by emptying it of its meaning and sowing confusion between the notion of discovery and invention. According to other authors, there is a risk of commercial drift if any element of the human body is patentable once it is isolated from it. These authors express concerns about the confiscation of genetic knowledge. Genes are likely to be multifunctional. Granting a monopoly on the exploitation of these genes before all their properties and their potential field of use have been identified is dangerous for society and medical research, as the grant of the patent could freeze other innovations. This explains to some extent the controversial nature of the directive, not only by the European Parliament, but also by some member states. These criticisms are likely to be amplified by the position of the US Supreme Court, Federal Court. Indeed, the Supreme Court, in its myriad genetics judgment, reverted to its original position, allowing DNA sequences to be patented. Now, for the court, DNA is a product of the nature and therefore not patentable. Directive 98/44 has not yet been amended on this point. Although these criticisms can be understood by the literal readings of the directive and its application by the European Patent Office, they must nevertheless be qualified. Indeed, as the Commission points out, Article 5 of the directive must be interpreted within the general framework of the directive itself and the protection it provides. The directive thus imposes additional requirements, particularly when it comes to examining a patent application. The classic conditions of patentability apply fully: novelty, inventive step, and industrial application. The industrial application of sequences of partial sequences must be set out in concrete terms in the patent application as field, and for the criterion of industrial application to be met, it is necessary in the case where a sequence or partial sequence of gene is used for the production of protein or a partial protein, to specify which protein or partial protein is produced or what function it performs. The paragraph 3 of Article 5 also adds to this. According to that article, the industrial application of a sequence or partial sequence of gene must be concretely stated in the patent application. The doctrine interprets these provisions as posing two strict conditions. It is a question of identifying a function to the gene inventive activity and conferring a concrete utility to that function, industrial application. Thus, in view of the controversy raised by the directive when it concerns human living or biological matter, it is for the European Patent Office and the Court of Justice to further clarify the scope both with regard to patentable biological material and invention prohibited under Article 5 and 6 of the directive. Initially, the Court of Justice used the classical technique of complying with the requiremits of the directive when it was transposed by the member states. In its judgment in Commission versus Italy, the court recorded the spatial nature of Article 5, paragraph 2 of the directive because it seeks to grant specific rights with regard to the patentability of elements of the human body. In that record, even if that provisions provided for a simple possibility of patenting, it imposes on the member states, as is apparent from recitals 17 to 20 of the directive, the obligation to provide that their national patent law does not exclude the patentability of isolated elements of the human body in order to encourage research aimed at obtaining and isolating such valuable elements for the production of medicines. Similarly, as regards to Article 6 of the directive, the court recalls the court recalls that under Article 6, Article 6 of the directive, Article 6, paragraph 2 of the directive, processes for cloning human being, processes for modifying the germline genetic identity of human beings are not patentable. The use of human embryos for industrial or commercial purposes, processes to modify the genetic identity of animals in such a way as to cause suffering without substantial medical utility for humans or animals, and animals resulting from such processes. It should be noted that, contrary to Article 6, paragraph 1 of this directive, which leaves the administrative authorities and courts of the member states a wide margin of discretions in applying the exclusion from patentability to inventions whose commercial exploitation would be contrary to public policy and public morality. Paragraph 2 of the same article leaves no margin for discretion to member states as regards to non-patentability of the processes and uses listed therein. This provision being intended precisely to frame the exclusion provided for in paragraph 1. In this respect, it is clear from the fourth recital in the preamble to the directive that the patentability of processes for cloning human beings must be excluded univocally, since there is a consensus on this issue within the community. It follows that by explicitly excluding the patentability of the processes and uses referred to therein, Article 6, paragraph 2 of the directive seeks to grant specific rights on this point. This provision obliges states to transpose it expressly in their national legal system. Secondly, in the Brussels judgment, the Court of Justice used the method of autonomous interpretation to define the concept of embryo under Article 6 of the Directive 98, 44. This method is chosen by the judge when he is faced with the problem of uniform application for a given regulation. In that judgment, the court first found that the directive made no reference to the rights of member states for the definition of that concept. The court concluded that only an autonomous interpretation was possible. The concept of embryo being to be considered as a concept of European Union law, which is independent in view of the objectives of the directive. Secondly, having regard to the primary objective of the directive and to the place of human dignity in the European Union law, the Court of Justice held that only a broad interpretation of this concept could remedy the conceptual differences between the embryos in the member states, and not merely allow the directive to be effective, but also the protection of human dignity and the human body. Although this method does help to remove the ambiguity of the terms used in the directive, it was quickly shown its limits. Indeed, in the International Stem Cell Judgment, the Court of Justice has reverted to this bold approach. In that judgment, it favored a casuistic assessment of the unfertilized ovum to be handled in order to determine whether or not it can, by being technically stimulated, develop into a human being. This confirms once again that the solution of case law can only be temporary. It cannot replace in a union governed by the rule of law, the union legislator. While it can fill gaps in the text, it cannot broaden its scope. The solution remains limited to the specific facts of each species and leads to an in situ and in concreto approach to Article 5 and 6 of the directive. While such an approach is undoubtedly of interest, it shows it limited, in particular by the questionable solutions to which it can lead in the absence of a conceptual clarification of the principle of non-commercialization of the human body. The comparison of this principle with the freedom to provide services is a perfect illustration of this situation. So, do you have any question? Everything is clear for you? Everything is okay? So, now I will present it. I will present in another legal issues, another ethical issues concerning the commercial exploitation of the human body. And now, in the light of the free provision of services involving the human body. Since the Grogan judgment, it has been accepted that the notion of service within the meaning of the treaty may include activities which affect the human body, and the freedom of personal choice fostered by free movement, while the economic benefit of the practice of abortion is not directly addressed in this judgment. It has been explicitly raised with respect to prostitution, and the exception from the value from the text system of economics activities involving elements of the human body. Do you have any questions? Excuse me, everything is okay?
Yes, everything is fine.
Okay, thank you very much. And especially, okay, donc especially with the value-added tax system of economic activities involving elements of the human body. So you'll see these 2 points, and we are going to finish the courses for today. So first of all, the prostitution and the free provision of services. Why do I focus my presentation on this point? Because there is some commercial exploitation of the human body determined by the free decision, okay? And the link could be made with the different provisions of the European Union law concerning, for example, the clinical trials or to abortion, okay? Not the same context, but the same ethical principles. Okay, though it is important to see what is the approach defined by the European Union law within the logic of the internal market. Okay, that's important point to understand why I'm insist on this point and why I will talk about the present this situation. Okay, it's clear that there is no consensus among the EU member states on prostitution. They have a margin of discretion to decide in their domestic law the prohibited or authorized character of the prostitution, based in the end on the defense of a national conception of human dignity, of personal autonomy, and the right to self-determination and the right to dispose of one's own body. Reflecting an ethical and national choice, prostitution is not a priori part of the concerns of the European Union, and yet it is not absent. In its resolution on sexual exploitation and prostitution and their consequences for equality between men and women, the European Parliament had formally taken a position against prostitution, whether it is voluntary or forced. The issue of prostitution is also considered through the lens of the fight against trafficking in human beings and the protection of children. But this text, whose legal value is not binding, do not express a view on the question of prostitution in relation to the ethical principle of not commercialization of the human body and the right to self-determination. The Court of Justice had to be seized of these questions. It was not to rule on prostitution as such, but on the exercise of freedom of movement and the restrictions that states may place on it on the grounds of their national choice to regulate or prohibit prostitution. In its judgment, Malgorzata Gianni, the Court of Justice thus explicitly linked prostitution with the free exercise of the provision of services. The facts of this case are relatively simple. 6 Polish and Czech women are resident in the Netherlands and work as without shoppers. They had applied for a residence permit in order to be able to carry out this activity independently. Their request was rejected on the grounds that the prostitution is a prohibited activity, or at least is not a socially accepted form of work. It cannot be considered as either a regular job or a liberal profession. In the face of repeated refusals and rejection of the application, the Czech and Polish nationals invoked the association agreements because the two countries were not at this moment full members of the European Union. In particular, the possibility of benefiting from freedom of establishment and provisions of services on the basis of those agreements. In its reply, the Court of Justice accepted, first of all, the direct invocability of the association agreements. Then, the Court of Justice ruled on the application of the provisions relating to freedom of movement invoked in relation to the activity involved prostitution. In order to qualify prostitution as an economic activity within the meaning of the association agreements, the Court of Justice states that it is sufficient to note that it consists of an activity by which the service provided satisfies on a fee basis a request from the recipient without producing or disposing of material goods. Prostitution is therefore a paid service that falls within the concept of economic activity. The activity of prostitution as a self-employed person can be considered as a service provided for remuneration and therefore fall under two falls under these two concepts. It is only after having qualified prostitution as an economic activity that the court recalls that, with regards to the immorality of the prostitution activity referred to by the referring court, it is also important to recall that, as the court has already held, it is not for the Commission to substitute its assessment for that one of the legislators in the member states where an allegedly immoral activity is legally practiced. However, prostitution is far from being prohibited in all the members, is tolerated or even regulated by most of these states, and it's particular by the member state, Netherlands, concerned by the case in question. The court therefore examines the restriction imposed on the exercise of that activity in the light of the traditional criterion of proportionality. If, in a fairly conventional way, the Court of Justice makes prostitution a derogation on the public morality or public order, which can restrict free movement, it mobilizes the principle of non-discrimination to limit the discretion of states, where the activity is regulated and allowed to their national. To use the words of the colleague Antoine Bayou, we can stress that the model working citizen who not only enters the market but triumphs, at least temporarily, over his rivals because he lives, as it should, on his paid work. It is not important, however, that this work involves activities of questionable morality, as the case law on prostitution demonstrates. The case law of the court, therefore, implicitly links the question of prostitution, albeit voluntary, to the personal choice of the national to travel in order to exercise it as an employee or self-employed person. And this is now this is what I'm exactly mean about the exemption from the value-added tax system of economic activities involving the human body, because the personal choice of the national to travel in order to exercise or to be or independently or under the quality of work is strongly connected with the tax system, because the case, in the light of the case law, the case law, the activity which involving human body are necessarily within the internal market, the economic activities. And now we have to face the ethical principles to determine if this economic, economic nature is compatible with the principle of not commercialization of the human bodies. Okay? Do you understand what I mean? Everything is okay? Okay. So I will take 3 minutes in order to take some cup of water, and we are going to continue in order to finish what I want to say today for the different topics. Now, the exemption from the value-added tax system. The value-added tax exemption, in turn, shows how difficult it is to reconcile the prohibition on profiting from the human body with the pursuit of an economic activity because of the financial stakes which VAT represents for the European Union as a proper resource, and on the other hand, of its confrontation with this ethical principle. The Court of Justice had to rule on this conciliation in connection with the transport activity involving human organs and samples, and in connection with private biobanks for the collection of umbilical cord blood. It also had to take a position on the prohibition of taking advantage of the human body and its linkage with the exercise of an economic activity. Thus, in the judgment in Nathalie de Fruitier, the Court of Justice had to rule for the first time on the applicability of Article 13 of the 6th Directive 77/388, which exempted from value-added tax supplies of organ, blood, and human milk. The applicant carried out as an independent person a transport activity involving organs and human samples for various hospitals and laboratories in Belgium. The Belgian tax authorities submitted its activity to it for VAT system, a decision which was challenged by the applicant on the grounds that Belgian law prohibited trade in human organs and levies. But the Court of First Instance and the Court of Justice gave reason to Madame Fruitier. Indeed, the Belgian administration brought an appeal. Before the Court of Cassation, it defended the idea that the delivery of human organs and samples, in this case, was more a service provision and therefore did not fall within the exception provided for by the directive. In these circumstances, the Belgian Court of Cassation has given up its examination and referred the matter to the Court of Justice for a preliminary ruling. Thus, the court had to rule on whether the notion of delivery of goods could be applied to the delivery of organs, blood, and human milk. In other words, if the independent transport of those goods consists of a transfer operation by one party, which entitles the other party to dispose of them as if it were the owner of that property within the meaning of the directive. Answering that question, the Court of Justice first pointed out that the concepts contained in the directive were open to interpretation, and then the consequently the exemption to that directive were strictly interpreted. In strictly interpreted. Then stated that within the meaning of the directive, a delivery of property necessarily involves a transfer of power to dispose a tangible property in the same way as an owner. In the present case, the court held that the carrier was merely physically moving organs and samples of human origin from one place to another on behalf of different hospitals and laboratories. The latter had not authority to dispose of it as if it were its owner. The court, therefore, concluded that the transport of human organs and samples was considered to be a service and consequently did not fall within the scope of the exemptions. The solution adopted by the Court of Justice is perfectly understandable. The situation in dispute did not in itself present any particular difficulty. The court could have left it at that. But the situation before the court ultimately posed a more ethical question in view of the absolute prohibition in Belgian law of trade in human organs and human removal. Should, under the pretext of this prohibition, carriers be allowed to be exempt from the value-added tax system, and therefore the tax system applicable to a services activity be brought into dispute? In order to answer this question, the court refers to the ethical principle of not commercialization of the human body and its products and the prohibition of profit resulting from it under Belgian legislation and the Oviedo Convention. However, it considers that this principle should not be regarded as an absolute principle which would deprive the strict interpretation of value-added tax exemptions of any useful effect. The court thus states that in other member states such transactions could be lawful, particularly where they concern to human milk and consequently may benefit from the exception provided for in Article 13 of the 6th Directive. This means that the court does not exclude that certain transactions may involve a transfer of ownership and consequently be qualified as deliveries of goods which may be exempted under the exception strictly referred to in Article 13 of the Directive. The reasoning of the court is surprising because it takes into account two parameters: the qualification of delivery of goods and the value-added tax exemption, which underlie a transactional logic. It is also surprising because the Court of Justice finally makes a distinction or even a hierarchy between product of the human body, those which can be the subject of a transaction such as breast milk, and those which will be excluded in principle. However, in the Kopichin judgment, the Court of Justice had to rule on whether the activities of a private biobank relating to collection, the transport, analysis, and storage of cord blood for possible use of stem cells taken from it for future autologous medical treatment were liable to be exempted from value-added taxes. Excuse me. In particular, the court had to decide whether the private nature of the biobank precluded the collection and storage of blood from being considered as an operation closely related to hospitalization and medical care that may be eligible for exemption. In this case, Copychain was a private biobank, but licensed and qualified as the competent establishment under the Directive 2004/23 on the donation of human tissues and cells. The samples were always taken in a hospital setting, with the collected cells remaining the property of the child whose cord blood has been taken into permission. Of his parents for the treatment of a disease. In order to refute such a qualification, the Court of Justice relies exclusively on the use of the stem cells collected. She believes that these cells can only be used for medical treatments, namely transplants, to the exclusion of all other purposes, such as research. Such treatments involve complex medical procedures that would normally or even always be performed in a hospital setting. To the extent that such treatments are intended to treat and, as far as possible, cure diseases or health anomalies, they fall within the concept of medical care referred to in the value-added tax directive. However, in order to qualify the co-activity an incidental to a hospital stay or medical procedure, in accordance with the directive, the Court of Justice relies on the potential character, the prospective medical treatment based on stem cells to estimate that Copychain's activity could not be covered by the exception provided for. This position is consistent with the European Group on Ethics advice on commercial cord blood and tissue donations banks. In its opinion, number 11, the European Group on Ethics on the ethical aspects of tissue banks highlighted the issue of non-commercialization of the collected body parts, but also the health, safety imperative. It also drew attention to the importance of conducting surveys among member states whose objective is to inform the public about the existence and functioning of these banks. In its opinion, number Number 19, the European groups on ethics had to decide on the same ethical issues as those raised by the banks of blood taken from the umbilical cord. Thus, it confirmed its position of principles already adopted in Opinion 11, number 11. However, it stated that it is questionable whether commercial banks of cord blood for autologous use are legitimate in that they offer service which to date has no real usefulness in terms of therapeutic possibilities. These banks therefore promise more than they can offer. Their activities are subject to serious ethical criticism. In conclusion, in conclusion, I could stress that the link between the value-added tax system and the ethical principle of not commercialization of the human body is particularly illustrative of the difficulty of effectively prohibiting the exploitation of the human body. The legal categories provided for in European Union law are not a priori appropriated to understand the ethical concept. The result in a case-based approach to reconciling the development of economic activity as a means of achieving the internal market with the affirmation and, above all, the effective scope of ethical principles. Added to this is the political discretion of the member states for their implementation. Thus, the Court of Justice make into account a both of terminology proper to European Union law, the economic nature of the activity carried out, and the special nature of the human body, and the ethical principles it implies, together with the values and objectives of the Union in respect of human dignity. The result is a slight conceptual terminology blur, which ultimately reinforces the initial observation. The principle of not commercialization of the human body is an exception to the exercise of economic activity and therefore must be interpreted in situ and in concreto. The prism of economic activity is interesting because it avoids taking a position of an ethical question and allowing all the exercise of this activity. But this prism is not entirely satisfactory in that it negatively perceives the principle of not commercialization of the human body as a limit. It examines the relationship between the free movement within the internal market and the political discretion of states from a conflict point of view. However, while it easily admitted and affirmed that the human body must be off-market and therefore not be the subject of commercial transaction, it is illusory to think that it should be absolutely excluded from free movement, as well as its element. It is on this last point that the prohibitions of taking advantage of the human body make its full sense as an unethical principle promoting the emergence of a European rights to union law of bioethics in isolation from economic activities. So that's the final words of the courses today. And next week, we are going to develop together the last topic on of our courses concerning the European Union law on donation and the new ethical challenges involved by the development of the protection data and establishment of health of European health data, health data. So see you next week. Everything is okay? Do you have any questions?